a voluntary confession written down by detectives, witnessed by a father who heard it with his own ears. And yet a not guilty plea, a jury trial demanded, and a defence attorney who is already sharpening every legal tool available before a single juror is seated. This is the story of how Joseph Duggar's own words may become the most powerful weapon the prosecution ever needed, and why his lawyers are doing everything in their power to make sure those words never reach a courtroom. If you are new here, hit that like button and subscribe right now, because this channel goes deeper than the headlines, deeper than the family-friendly narrative, and deeper than anything the mainstream media is covering in this case. You are not going to want to miss a single episode of this series. Now let's get into it. Here is the legal paradox sitting at the centre of this entire case. Joseph Duggar admitted what he did. He admitted it to the victim's father on March 17th. He admitted it shortly after to detectives from the Tontitown Police Department. The admissions were made. The words left his mouth. And then his attorney filed a not guilty plea, waived the arraignment, and demanded a jury trial in Florida. So the question that every legal analyst, every true crime observer, and frankly every person paying attention to this case has to ask is this: how do you take something to trial when your client has already admitted to it? That tension, that contradiction, is the engine that is going to drive everything you're about to hear. Let's start with what the word confession actually means inside a Florida courtroom, because a lot of people use that word loosely and the law does not. In legal terms, there is a significant difference between a voluntary admission and a coerced confession, and that difference determines whether a judge ever allows a jury to hear it. A coerced confession, one obtained through threats, physical pressure, psychological manipulation, or by violating a defendant's constitutional rights, can be thrown out entirely before trial even begins. A voluntary admission, something a person says freely without being forced, without being under formal arrest, and without being denied access to an attorney, is a completely different animal. It is almost always admissible. It is almost always devastating. Now let's talk about Miranda rights, because this is where things get genuinely interesting for Joseph's defense team. Most people know Miranda from television. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. But here is what most people do not know. Miranda rights only apply in very specific circumstances. They apply when a person is in custody, meaning they are not free to leave, and when they are being formally interrogated by law enforcement. If you are not in custody, law enforcement does not have to read you your rights before asking you questions. And anything you say in that context is completely fair game for prosecutors. This matters enormously for Joseph Duggar. His conversation with the victim's father on March 17th, that conversation almost certainly did not involve law enforcement at all. It was a private exchange between two people. There is no Miranda protection that applies to what a person says to a civilian, no matter how incriminating it is. If the victim's father goes to that witness stand and tells a Florida jury exactly what Joseph Duggar said to him that day, there is virtually nothing the defense can do to stop it. That conversation is on the record. It is in the evidence. It is the case. The conversation with Tontitown detectives is more legally complicated, and this is where Joseph's attorneys will spend the majority of their suppression arguments. Was he Mirandized before speaking to those detectives? Was he technically in custody at the time of that conversation, or was it framed as a voluntary interview? There is a meaningful legal distinction between a detective calling someone in and saying, "We would like to ask you some questions, you are free to go at any time," versus a formal custodial interrogation where a person is under arrest or reasonably believes they cannot leave. If the Tontitown interview was conducted without Miranda warnings and a court later determines that Joseph was effectively in custody, his attorneys will argue that everything he said in that room should be suppressed. That argument is not guaranteed to succeed, but it is the argument they are going to make. Now let's talk about something that almost never gets discussed in coverage of cases like this, the psychology of why people confess before a lawyer ever walks through the door. Because for a lot of people watching this, the natural question is, why would anyone admit to something this serious without legal counsel present? Why would Joseph Duggar say what he said to the victim's father, "of all people." Why would he speak to detectives without demanding an attorney first? And the answer is complicated, and it matters for understanding this case. The psychology of pre-arrest confession is well documented. People confess for several consistent reasons. Guilt, the crushing weight of knowing what you did, and the psychological relief that comes from saying it out loud. The belief, almost always incorrect, that honesty will result in leniency. The social pressure of a confrontational encounter, particularly when the person confronting you is a parent figure or an authority figure whose approval you have spent your entire life seeking, and perhaps most significantly in this case, a religious and cultural framework in which confession is not just morally expected, it is morally required. Joseph Duggar grew up in a household where confession to authority figures was standard practice. The Duggar family's particular brand of evangelical Christianity places an enormous emphasis on confessing wrongdoing to parents, to church elders, to accountability partners. Josh Duggar's own childhood offences were handled through exactly this framework. Sin daw sa say, confess, repent, receive forgiveness, move forward. That model of confession as the appropriate response to wrongdoing is deeply embedded in how the entire family was raised. And the cruel legal irony is that the very religious framework that was supposed to produce accountability may have produced the most incriminating evidence in Joseph's case. He confessed because that is what he was conditioned to do. He confessed because in the world he grew up in, confession to an authority figure was the right thing, the moral thing, the expected thing. He may never have stopped to consider that in a Florida court of law, that confession becomes the prosecution's most powerful weapon. Now let's get into the specific details of the Bay County arrest affidavit, because this document reveals exactly how seriously prosecutors are taking this case and exactly what kind of evidence they are building. The Bay County Sheriff's Office arrest affidavit describes how the victim, a 14-year-old girl at the time of the affidavit, gave a forensic interview in 2026 about incidents that she says occurred during a 2020 vacation. 6 years between the alleged incident and the formal forensic interview. We are going to come back to that timeline in a moment because it is significant. But first, let's talk about what a forensic interview actually is, because this term gets used in legal documents all the time and most people do not fully understand what it means. A forensic interview is not a casual conversation. It is not a detective sitting across a table and asking a child questions. A forensic interview is a highly structured, legally specific, professionally trained interview process designed to gather credible, court-admissible testimony from minor victims in a way that minimizes contamination, leading questions, and trauma re-exposure. The interviewers are certified, the methodology is standardized, the sessions are typically recorded. The entire purpose is to produce testimony that will hold up under cross-examination in a jury trial. When prosecutors choose to conduct a forensic interview with a minor victim, that choice signals something important. They are not just trying to get information, they are building a case. They are thinking about a jury. They are constructing evidence that is designed specifically to survive the most aggressive defense, attorney cross-examination imaginable. The fact that a forensic interview was conducted in this case tells you everything about the prosecution's intentions. They are not looking for a quiet resolution. They are not angling for a deferred sentence or a quiet plea. They are building a Florida jury trial case from the ground up. And the forensic interview of a minor victim is one of the foundational pieces of that structure. Now let's talk about what Joseph's attorney actually filed and why the specific language in that filing matters more than most people realise. When the not guilty plea was entered and the jury trial was demanded, the attorney included this specific language. This plea shall maintain the defendant's right to raise any and all procedural motions, objections, or defences. If you are not a lawyer, that sentence might sound like standard boilerplate. It is not. That sentence is a legal declaration of war. Procedural motions is not just legal jargon. It is an attorney code for something very specific. We are going to challenge every single piece of evidence in this case, every procedural step law enforcement took, every statement made by our client, every interview conducted, every form filled out before a single juror is ever seated in that courtroom. The not guilty plea and the jury trial demand are not a declaration of innocence. I want to be very clear about that because it matters. A not guilty plea in the American legal system is not the defendant standing up and saying, I did not do this. A not guilty plea is a procedural position that says, prove it. It is the opening move in a legal chess match. It is the defense team buying themselves time to file suppression motions, time to review discovery, time to challenge the admissibility of every piece of evidence the prosecution intends to use. The not guilty plea gives Joseph's attorneys the legal room to fight. And the thing they are going to fight hardest is the confession. So let's walk through the three most likely suppression arguments his defense team will make. And let's be honest about the probability of each one succeeding. Scenario one, they argue that the conversation with Tontitown detectives was a custodial interrogation conducted without Miranda warnings. If they can convince a judge that Joseph was effectively in custody during that conversation, that a reasonable person in his position would not have felt free to leave, and then the Miranda violation argument has legs. If that argument succeeds, everything Joseph said to those detectives could potentially be excluded from trial. This is the defence's strongest legal argument on paper, but it requires a factual record that actually supports it. If the detectives documented that Joseph came in voluntarily, that he was told he was free to leave at any time, that the conversation was framed as a voluntary interview, the custody argument becomes very difficult to sustain. Scenario two, they challenge the admissibility of the victim's father's account as hearsay. Hearsay, for those unfamiliar, is an out-of-court statement offered to prove the truth of what was said. Normally hearsay is inadmissible, but there are dozens of exceptions to the hearsay rule, and one of the most powerful is the admission by a party opponent, which means that anything a defendant said outside of court can almost always be used against them in court. It is not hearsay when it is the defendant's own words. The victim's father testifying about what Joseph said to him is almost certainly not going to be excluded on hearsay grounds. That argument is a long shot. Scenario three, they challenge the forensic interview itself, arguing it was conducted improperly or that the methodology used was flawed in some way. Josh Duggar's defense team tried a version of this strategy, attacking the methodology and integrity of the evidence. In Josh's case, they were attacking digital forensic evidence on a computer hard drive. They brought in experts, they raised questions about chain of custody, they suggested alternative explanations. The jury convicted anyway on both counts after a remarkably short deliberation. In Joseph's case, the defense would be attacking a forensic interview of a human being, a 14-year-old girl who will likely testify in person. Attacking the methodology of a forensic interview in front of a jury while that child is present in the courtroom is an extraordinarily high-risk strategy. Juries do not respond well to defense. Attorneys who appear to be aggressively challenging a minor victim's credibility. The jury, optics alone make this approach dangerous for the defense. Here is the bottom line on suppression. Suppressing a voluntary pre-arrest admission made to a civilian is nearly impossible. The legal standard for excluding that kind of statement is extraordinarily high. Short of the victim's father being caught in a material lie or some extraordinary chain of custody failure, that conversation is going into evidence. The only real suppression fight with a realistic chance of success is the Miranda argument about the detective interviews. And even that depends entirely on the factual details of how that conversation was structured and documented. Now, I want you to imagine something for a moment. Close your eyes if you need to, but stay with me because I want you to actually picture what is at stake here. Picture a Florida courtroom. Wood paneling, fluorescent lights, 12 jurors in the box, people from ordinary walks of life who have been selected specifically because they can be fair and impartial. Picture a 14-year-old girl on that witness stand testifying about something she says happened when she was 9 years old. 9 years old. A forensic interview tape playing on a screen in that courtroom. Detectives taking that stand and reading back word for word what Joseph Duggar admitted to them. And then picture a defense attorney standing up in front of those 12 jurors and trying to construct some alternative explanation for all of it. Florida juries in cases involving child victims and defendant admissions have a well-documented history. When prosecutors can bring together victim testimony, a forensic interview and a defendant's own admission, all three elements in the same case, the conviction rate is extraordinarily high. We are not talking about a close call. We are talking about the kind of case that prosecutors call a strong case, a case they are confident taking to trial, a case where the evidence alignment is almost exactly what you want if you are sitting at the prosecution table. And this is why we need to talk about the most strategically realistic question in this entire legal situation. Will this case ever actually go to trial, or is the not guilty plea and the jury trial demand just a negotiating position? Because the uncomfortable truth about the American criminal justice system is that the vast majority of criminal cases, somewhere in the range of 90 to 95%, never go to trial at all. They resolve through plea agreements, and the cases most likely to resolve through plea agreements are the ones where the prosecution's evidence is strongest. The stronger the case against a defendant, the more leverage the prosecution has in plea negotiations. And the more leverage the prosecution has, the more likely a defense attorney is to advise their client to consider a deal rather than risk a jury verdict. Joseph's team will try to suppress the confession first. That is the obvious opening move, and it makes sense regardless of what happens next. If suppression succeeds and if a judge excludes the detective interview, the prosecution's case becomes measurably weaker and the leverage shifts slightly toward the defense. If suppression fails, which is the more likely outcome, expect something interesting to happen in the months that follow. Expect quiet conversations between attorneys. Expect motion filings that slow the timeline down. Expect continuances that push the trial date back. Because when suppression fails and a defense attorney is sitting across from a client who has already admitted to the conduct being charged, the calculus of going to trial versus accepting a negotiated resolution changes dramatically. The not guilty plea and the jury trial demand are almost certainly negotiating positions. They are the defense team saying, we are prepared to fight this to the end, and that preparation is going to cost you time and resources, and maybe it is worth having a conversation about how this resolves without a full trial. That is a legitimate legal strategy. It is not dishonest. It is not cynical. It is how the system works. The plea gives them options. The jury trial demand gives them leverage. And the procedural motions language gives them the ability to slow everything down while they figure out whether fighting this to a verdict is actually in Joseph's best interest. But here is the thing, and I want to be very direct about this. There is a real possibility, however slim, that this actually does go to trial. Joseph's family has resources. His legal team is not inexperienced. And there are defendants who, for reasons of principle or strategy or genuine belief, take cases to trial even when the evidence is stacked against them. If this goes to trial, I want you to understand exactly what that looks like. It looks like Josh Duggar's trial, but harder. It looks like a prosecution presenting a victim, a forensic interview, and a defendant's own admission, all in the same case, in a Florida courtroom to 12 jurors who are going to be asked a very simple question. Do you believe what you are seeing and hearing? Josh Duggar's attorneys were sophisticated. They brought in forensic computer experts. They raised serious technical questions about the evidence. They constructed an alternative theory about who placed those files on that hard drive. They did everything a competent defense team can do. The jury convicted on both counts after deliberating for a matter of hours, not days, hours. And Josh's case was built on digital evidence, evidence that by its nature is technical, abstract, and subject to genuine expert disagreement. Joseph's case is built on something far more immediate. A father who heard words come out of Joseph's mouth. Detectives who wrote those words down. A child who can look a jury in the eye and tell them what she says happened. That is not abstract. That is not technical. That is human. Testimony layered on top of an admission, and it is the kind of evidence that resonates in ways that hard drive forensics simply cannot. If Josh's defense failed against technical evidence, the hill Joseph's defense has to climb is steeper, not impossibly steep, not a guaranteed outcome, but steeper. Here is something else worth understanding about this case that almost no one in mainstream coverage is discussing: the significance of the 6-year gap. The alleged incidents occurred in 2020. The forensic interview happened in 2026. 6 years is a long time. And a defense attorney worth their fee is going to raise questions about memory, about the reliability of a 9-year-old's recollections being reported by a 14-year-old, about what happened in those 6 years, about who the victim spoke to, about whether those conversations influenced her account. That is not an unreasonable legal argument. That is not attacking the victim. That is the kind of scrutiny that the American legal system requires. But here is the problem with that argument in the context of this specific case. The defendant's admission exists independently of the victim's memory. Even if a defense attorney successfully raises doubts about the reliability of a recollection from 6 years ago, Joseph's own words to the victim's father and to those detectives are not dependent on anyone's memory but his own. He said what he said. And those words were documented before any forensic interview, before any legal proceedings, before any of the 6-year timeline became legally relevant. A lawyer can challenge a memory. A lawyer can challenge digital evidence. A lawyer can challenge the methodology of an interview. But a lawyer cannot challenge the moment a father heard those words and knew exactly what they meant. A lawyer cannot undo a documented admission made to law enforcement. A lawyer cannot unring that bell. The confession is not just a piece of evidence in this case. The confession may be the case. And the case, regardless of how the procedural chess match plays out over the coming months, is almost certainly going to change the trajectory of this family's public story in ways that no reality television contract, no Instagram post, no carefully curated family image can offset. We are watching a legal process unfold in real time, and the outcome of that process, whether it ends in a plea agreement, a jury verdict, or some other resolution, is going to tell us something important. Not just about Joseph Duggar, about the legal system's handling of cases like this one, about the gap between public image and private reality, about what accountability actually looks like when the evidence is this direct and this documented. Here is where I'm leaving you today. The not guilty plea is not the end of this story. It is the beginning of the legal fight. And that fight is going to be decided not in press releases, not in family statements, not in carefully worded attorney filings. It is going to be decided on the question of whether those words Joseph said are going to reach a jury. If they do, this case becomes very difficult for the defense to win. If they are suppressed, everything changes. That is the fulcrum this entire legal situation turns on. And we are going to be watching every motion, every hearing, every filing, every development as it happens. Drop in the comments right now. Do you think this goes all the way to a jury trial, or do you think we see a plea deal negotiated quietly before summer? I genuinely want to know what you think is going to happen, and I read every single comment on this channel. Subscribe if you have not already, because topic 8 is the episode that asks the question nobody in mainstream coverage has publicly raised yet. Where exactly was the victim's family in 2020? Why did it take 6 years to come forward? And what does that timeline tell us about how this case was actually built? That episode drops next. Do not miss it.